Morning.
Good morning. How you doing?
I'm okay. How are you?
Very good.
So you're Corbin Riley?
Yes, ma'am.
And Mr. Riley, you were here just last week or the week before.
Yes, ma'am.
And you pled guilty to an offense and you were told to go to the probation department and do a pre-sentence report.
Yes, ma'am.
And I've gotten a memo. So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right? Good morning. Are you Nier Brown?
I'm not here today. Special appearance.
I'm sorry. Speak up so I can hear you.
Here today.
You're appearing here today?
I have special appearance.
Okay. What is your name?
I'm a third party intervener who's behalf of an artificial legal entity, not Nier Brown.
Okay. At one point in your, at some point in your life prior to being this third party, were you Nier Brown?
No.
You're not him.
I'm a third party intervener.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
That's relative.
So are you Nier Lewis Brown or have you been him at some point in your life or not?
Yes.
Okay. So I'm going to call you by Mr. Brown because I'm not going to say all the words that you just said because you have now identified yourself as Nier Lewis Brown. And so, Mr. Brown, this is your initial appearance and you have two cases. And cause number 26, I just asked you not to speak over me. So here's the thing, Mr. Brown. I'm going to be very patient.
And at the time, subject matter jurisdiction, going on record.
Your challenge of the subject matter jurisdiction is overruled. Let me go through what I need to go through, okay? So this is your initial appearance, your first day in court. I'm required to go through what you're charged with by indictment. In cause number 26, DCCR 0322, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation from February 16th of 2026. And then in cause number 26, DCCR 0323, you're charged with the state jail felony offense of injury to a child, and that's from February 16th of 2026. And so since you have made bond and got out of jail on your cases, have you had an opportunity to try to hire a lawyer?
This is what I'm saying.
Speak up so I can...
Up and down.
It's been up and down?
Yes.
Okay. So here's what I'm going to do, Mr. Brown, is I'm just like everyone else. I'm resetting your case about 30 days to give you some time to try to hire a lawyer. You need to try to get someone hired before the next court date. If you do, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you would go back to jail. Do you understand? I'm sorry?
Overstand.
Say it again.
Overstand.
You overstand?
Yes.
Okay. What does that mean?
Overstand.
Do you understand what I'm saying, sir?
I'm blind.
You'll oblige?
I'm blind. Yeah.
Okay. You just determined to use different words and be difficult, aren't you?
No.
Okay. So as a condition of your bond, did you have a condition that you were not to have any contact or communication with the complaining witnesses in each of these cases, right?
Yeah.
Okay. And so I want to make sure you understand the importance of that. And that if you do have any contact or communication with either of them, it would be a violation of that bond condition. If I find out your bond would be raised and you would go back to jail. Do you understand that as well?
Overstand.
You overstand.
Same thing.
I'm going to guess that overstand is even better than understand. So you definitely know what I'm talking about, right? So we don't have any miscommunication today. You know exactly what I'm talking about.
Yes.
So I'm going to have you step in front of the clerk. You're going to sign a reset notice so you know when to be back in court and take care of those things before the next court date. All right, let's step in front of the clerk. Are you Nier Brown? I'm sorry?
You've been here before.
You've been here before, but you have to speak up where I can hear you.
You've executed beneficiary of the trust in hand.
Of the trust of what?
Of the trust in hand, yeah.
Of the trust in hand? Whose hand? What trust?
The execution.
Did you bring a copy of it?
I wasn't able to get to the copy. I do
Take the glasses off. I need to see your eyes, please.
These are my prescription glasses.
That's okay. So I'm having a hard time understanding you. You need to speak up and speak clearly so that the record can be clear. You were already here and I gave you an opportunity to try to go hire a lawyer for your 2 cases. Did you get a lawyer hired?
They did do it.
Who'd you talk to?
Made a few calls to the guy, Rafe. What's his name? Rafe King?
Mm-hmm.
What's his name again?
Who else?
That's the lawyer that I chose.
So if you chose him, you should have gotten him. I mean, he has the same, there's somebody that answers his phone every week. I understand. I know how it works. I told you to hire someone or visit with at least 3 lawyers.
Made an attempt.
You made an attempt? Okay. Did you go see Mr. Kimler? Did you make an appointment?
Able to do that.
Why not?
I'm not in a position to go back and forth in front of a lawyer that's invested that my fund. This is for the names.
So here's the thing, Mr. Brown, I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right?
No.
Yes, that's exactly what I say. Because you've heard me say it probably 8 times already this morning. So at this time, Mr. Brown, because you did not do what I asked you to do, or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started and don't make me lay hands on you. Why would you lay hands on me?
Because you're not doing what I'm telling you. Now go.
Mr. Brown, you need to go back with the bailiff. Right now, I've raised your bonds. You have to go with the bailiff.
Not a threat to any officer.
You through with him, Judge?
Yes, I'm through.
I am not a threat to any officer. Let's go. Why are hands on me?
Yeah.
Why are hands on you?
I told you I could put hands on you.
Why are hands being put on? Y'all see this on the camera?
And right there, put your hands on the wall. Okay, put your hands on the wall, but you're not listening. Oh, listen, I don't know that.
Good morning.
Good morning. How you doing?
I'm okay. How are you?
Pretty good.
So you're Corbin Riley?
Yes, ma'am.
And Mr. Riley, you were here just last week or the week before.
Yes, ma'am.
And you pled guilty to an offense and you were told to go to the probation department and do a pre-sentence report.
Yes, ma'am.
And I've gotten a memo from them that has some unfortunate information in here about how you acted while you were there and visiting with them.
Yes, ma'am. I was over the phone when me and the lady were arguing and stuff. I just wanted the information on when I was supposed to meet the these. That was it. And
That's not how this reads.
they
They were so frustrated with you that they said they will not do a pre-sentence report while you're on bond. So do you know what that means?
my bond had to be paid off.
No, that means I'm going to revoke your bond
Okay.
and you're going to go to jail.
Yeah.
And then they're going to come to the jail and do the pre-sentence report. And you're going to be respectful to them. Or I don't have to go along with this plea agreement.
Yes, ma'am.
So listen, it's time to get a whole different attitude about all of this. I understand. I remember now when you were here, you don't like the whole situation.
No,
Hang on. Don't overtalk me because that's going to show me what you're doing to them. Okay. Now it's just the time to listen.
Yes, ma'am.
All right. And just do what you're told. There's not an excuse for what you did. You didn't just try to ask for some information. Okay. They wouldn't have sent this. They're very, very patient.
I just want to let you know I got a whole different view about it on the whole situation now too. I just got to meet my son for the first time on Friday. So
Well, this is very unfortunate.
Yeah.
So but here's the thing. There's no reason for you to still not get this probation, but I don't have a choice now but to get this pre-sentence report done. So I'm going to, hang on, I'm going to revoke your bond in your case at this time. You're going to go with the bailiff. Probation's going to come to the jail. They're going to do this pre-sentence report. Probably not today.
Do I get a new bond today?
I'm not giving you a bond because you couldn't act right while you were on bond, which shows me that you see where I'm.
Yeah, can we just like revoke the deal and take it to trial? I can't afford to go to jail, please.
You're going to jail regardless. Why?
Yeah,
because do you want me to read the memo?
The whole thing. Yeah, can we play the voice recordings of the phone call in here today too, if that's the case? Because if you're just going to believe what she says, then I believe I have the right to fight on behalf of what I have to say, and we need to be able to play those phone recordings.
You're going to go do that. You're going to go do that pre-sentence report.
Phone recordings today.
And you're going to go and hopefully be respectful and hopefully get this probation and not ruin your life over this.
Oh,
this is
very. As long as you think I'll be in there.
It's a very temporary situation. Mr. Rojas can come back and talk to you. I'm revoking your bond at this time. I find it's in the best interest until sentencing that there not be a bond. You can go back with the bailiff.
I understand there's times for mercy, there's times for compassion. Well, I think undeserved mercy to skill and cruelty to the victims. And they've been through everyone's worst nightmare. 20 plus 20 is 40, and that's really not enough, but that is the maximum level under law, and that's what I'm asking you to do. On behalf of the Marty family, the Eisenhower family, Christopher Stacks, Boston Carr, and their entire faith community. The one reason all these people, including the Gomez family, are here in this courtroom today is because of what he did, what he chose to do. And it is a tragedy up and down. And so I'm asking you to protect citizens of Jefferson County from any chance that this can ever happen again with Mr. Gomez. Thank you, Your Honor.
Thank you. I have a question, Mr. Nichols, with regard to deadly weapon finding. I'm looking at the indictment, and it doesn't read that there's a deadly weapon.
I don't believe it does, Your Honor.
Okay. And it's not something I looked into. Is that something I can still find if the indictment doesn't say it?
Yeah, I don't have an answer for that.
Okay. Do y'all know? If it's not, if it's not in the indictment,
the court would have to find. It is permissible without a request, without it being included in the indictment. However, the court would have to point to specific evidence that it was used or intended to be used as a deadly.
okay.
And I would argue to the court that perhaps, if there had been other evidence, but there's really no evidence admitting upon which the court could make such a finding. So I would ask the court not to find it. But I will represent the court as an officer of the court, but it's not absolutely required.
Okay. I really didn't think so. I just wanted to make sure. I would think I guess, Mr. Young, would you disagree with the information that is provided in the pre-sentence report that everyone has agreed that I review, that I could use that as far as, since I've taken judicial notice of that, the letters and everything else, that would be, or would you have an objection for me of me using that if I were in fact to make a finding of a deadly weapon?
Your Honor, I think the court can consider all evidence before the court, and if there is evidence that the court point to that this supports the finding of a deadly weapon. I'll see if we can.
Okay. First, I really do want to thank everybody for being here. We don't have full courtrooms like this. These, just as both of the attorneys said, these are some of the most difficult cases that any judge has to deal with for many reasons, obviously. Mr. Gomez, had you been in, well, I'm not sure that it would matter, but had you been in here and this was your first DWI, there might be some sense of what your attorney was asking for me, which is true. I have to detach myself from the emotional part, which is, it's impossible, but it's required, and I do the best I can to do that. And there are things about you and your life in the past that are good, There are things that the 3 prior DWIs should have taught you. Your age, you're 52 now, 53 now. It's the 3 DWIs previously, even though they're older, and your age, it's not the establishment's fault. Did they violate the law? Absolutely. You're a grown man. Got into a vehicle, and from your history, from your age, probably from telling your own children not to drink and drive, and trying to probably instill that in them, and you did it, and you did this. So at this time, in cause number 24 DCCR 1651, I'm going to find you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter with a vehicle. I'm going to sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. I am basing that on all of the information that's presented in both the pre-sentence report, the attached reports from the officers, in addition to the letters from Mr. Stacks, who unfortunately had to drive up and see this in person, from what they had to use to identify these 2 precious young lives, that there's no way that there is any doubt that you used your vehicle in a manner capable of causing death, and that you in fact did that. In cause number 24 DCCR 1652, I'm also going to find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter with a vehicle. Sentence you to a term of 20 years. There will also be a deadly finding in that case based on the same information and evidence that I used in the previous one. That sentence will run consecutively to cause number 24 DCCR 1651. In cause number 24 DCCR 1653, I'm also going to find that you entered your plea of guilty freely and voluntarily, find sufficient